All right, we'll go to our program guest now, the Shadow Minister for Immigration, Scott Morrison, to talk about the Big Australia concept and the High Court decision this week on asylum seekers. Scott Morrison, good morning. Welcome.
Good morning, Barry. Good to be with you.
OK, well, let's put talk of targets to one side for a moment, but the reality is 40 years from now, 2050, Australia will have a much bigger population. That is inescapable.
Well, the Coalition always said there would be population growth. We weren't in the zero population growth camp, but at any time we said there needs to be sustainable population growth, and the Treasury report you referred to made two other important points. One was that a migration program had to be part of any population strategy, which was a point the government rejected during the campaign. And the second point is the report also said that the rate of growth we were having at the time, remember, which is between 250 and 300,000 net overseas migration, the Treasury report said was beyond the strategic capability of all tiers of government. And that was also a very important point that we were making in the lead up to the election, and we have since.
But on that more modest figure of 180,000 a year, that would still lead to a population of 36 million by 2050. Should we be alarmed by that?
Well, that figure of 180,000 was in the intergenerational report, and that was the average net overseas migration over that entire period that would produce that figure. And what we said in the election campaign, and remains our policy, is that we want to set a growth band for population growth, advised by the Productivity and Sustainability Commission, that would frame our migration program into the future. Now, we said we would get it down to 170,000 net in our first term, and the government said they were going to achieve that as well, actually, so we'll see what happens.
But if governments start doing the work now, surely we shouldn't fear a population of 36 million in 40 years.
Well, the big if there is if governments do the work now, Barry, and that's the point that I think has been looked over in this debate. Everyone agrees that you've got to put the infrastructure and the services and all of these things in place to meet population growth. What the Australian people have said to us pretty clearly is, and particularly in my home state of New South Wales, and I'm sure there are plenty of Victorian voters feeling the same way, unless the infrastructure gets delivered, then the population pressures are compounding the problem, not making it easier. And there needs to be, these two issues brought together, which is exactly what we propose with our Productivity Commission model.
Do you accept, though, that you don't cut migration numbers just to avoid some arbitrary population figure down the track, that you actually structure migration to fit the needs of the economy at the time?
Well, that's exactly why we suggested the Productivity Commission model, that you would have a target range of population growth. So it's all about the rate of growth. Whatever figure that turns up to be in 2050 or 2070 or 2030 will be what it will be. What the Australian people need to be comfortable about it is that we're running a migration program that firstly is focused on our skills needs, and secondly is not delivering a rate of population growth that cannot be sustained. And that's what our population policy was designed to address.
On that High Court decision, you said this week the only winners are people smugglers and lawyers. What about asylum seekers?
Well, again, if you're an asylum seeker sitting in a refugee camp somewhere around the world, then you're going to be less likely to get that opportunity now than you were before this decision. But let's be clear about what this decision was about, Barry. This decision was about a change to policy made in July of 2008. And for those who want to get into the detail of this, paragraph 70 of the judgment is the key paragraph. What it said there, and if you give me the opportunity, I just would like to make the point. What it said there is up until that time, there was a discretionary power of the minister to raise the bar to allow applications for visas, protection visas, for those who'd been found to be legitimate asylum seekers. It was purely discretionary. What changed in July 2008, the minister said we're going to no longer process people on Nauru, they're all going to be processed on Christmas Island, and as a result they will all each be decided upon whether we will use that discretionary power. So the court said it's no longer effectively a discretionary power, it's now part of a process. Now, the government's failure to think this through set up a whole new standard which the High Court found in practice wasn't being followed, and as a result the whole thing's fallen over.
But you're ignoring 2001. Isn't it true that what happened in that decision is that they used 2008 as evidence, the manuals from 2008 as evidence, but it actually applied to what occurred in 2001?
Well, no, there is not one section of this judgment that strikes down anything that was done in 2001. Excision still exists. The transfer powers still exist. Offshore entry person status all still exists. What changed in July 2008 was a change in the process. The Minister introduced a non-statutory process, which the court has basically said in implication was a statutory process, and in its practice was found to be deficient. In 2001, our changes specifically said that Section 75 of the Constitution challenges to the High Court still remained. So 2001, and there'll be plenty of people who want to throw shoes at this, I suspect, in terms of the Howard government policies, and that's predictable. But the fact is, let's look at what was done in the judgment. It dealt with what happened in July 2008.
Why do you say it was a terrible judgment?
Well, that wasn't a reflection on the High Court. I should be very clear about that. But it is going to have terrible consequences, and that was my point. Because we all know that in the bad old days...
terrible judgment. You didn't say there were terrible consequences.
Well, no, I did actually, and I've said it on several occasions since then, Barry. My meaning was that the consequences for Australia and the consequences of people now being able to game the system have been increased. And we don't want to see that. We don't want to see lengthy delays and lengthy procedures in our courts where people are using that system to prolong their stay. What we want to see is people's claims assessed. We've always supported a review by a second case officer, as is supported by the UNHCR all around the world. And then a decision, if one is to be made, is made after that. But to tie it up in our courts has never been a good way to handle these matters in our view.
So what do you think the government should do now? Should it try and legislate?
What the government should do is not deal in half measures, not continue their policy drift. They should adopt the coalition's policy. And that's what we're saying very clearly. We want to see them put in place policies that will address the unprecedented arrival of illegal boats to Australia. And if they're not prepared to do that, then we think they're dealing in half measures. We don't want to paper over. We want a fair income solution.
But there's nothing you can do by way of legislation as a result of the High Court judgment? There's nothing you need to do? There's nothing you need to do by way of legislation?
Well, the Nauru solution still remains completely intact. I mean, the Nauru solution was not in any way put at risk by this judgment this week, in the same way I'd concede that anything that may happen with the Never Never solution in East Timor is also unaffected. So I don't think that they are issues. There is a legislative framework that exists today that was unchallenged successfully all through the years we operated it, where similar appeal rights exist, and remains intact. They can do that tomorrow. They can pick up the phone to Nauru today. They can introduce temporary protection visas again. They can even use the Safe Haven 449 visas that are on their books today to address these matters. So we want to see them address policies to deal with their broader policy failures, not just this policy failure.
And presumably they can use East Timor as well, because there are no implications on this in terms of having a regional processing centre.
Yeah, well, the problem with the regional processing centre in East Timor is it's just never going to happen. They can't get support for it. I'm not surprised, because it's effectively an asylum magnet. Nauru can be done today. And that is the real difference between Nauru and East Timor, is that Nauru can actually happen. But this judgment doesn't go to the legitimacy of third country processing. If anything, I think it actually highlights the need for it. And that's why our policy is ready to go.
Is there room here, though, for the government to simply change the way that it processes asylum seekers by being more thorough, in effect, more thorough in making the assessments and effectively removing a lot of the grounds for appeal?
Well, I think the government has a wide array of things it can do, both statutory and in terms of process. But what we're saying to the government is we don't want to see just a papering over their failures that have been shown up in this High Court decision. We want to see them deal in introducing policies that have been proven and have worked in the past, and we want to see them restored. And if the government is not prepared to do that, then they should take nothing for granted from the coalition in terms of how we might receive any of their proposed changes.
Surely the most fundamental thing that the High Court did, though, was to simply make a judgment that asylum seekers, like everybody else, ought to be treated the same. They ought to all have the same access to fairness and the rights of law.
Well, what it said was the government's process that was set up was a non-statutory one, and as a result, procedural fairness provisions were implied and were created. Now, those fairness provisions can be limited by statute, and the government, I'm sure, is looking at doing just that. But there's a key point here, Barry. Still, those who arrive by boat will be treated differently than those who arrive in other methods. That hasn't changed under this provision. They are still deemed offshore entry persons, and they still would seem at the moment continue to have access to the High Court. What other courts they have access to, I agree with Chris Bowen. I think that's unclear. I'm sure it will be tested. But we want to stop the boats arriving, and we make no apologies for that. And we support a dual-track system which discourages boat arrivals.
Now, just finally, Paul Howes in his book made the observation about you and your visit to Nauru during the election campaign. He said it was disappointing. There are only 100 eligible Australians living on Nauru, 100 eligible voters, that is, and it's in Labor's interest to expose you to as many voters as possible. It's a bit harsh.
Well, I'm not going to help Paul Howes with his usual self-promotion campaign. The guy will get round in a skivvy soon and campaign to be the fifth Wiggle if it'll improve his profile. So, look, I'll let Paul throw whatever slings and arrows he likes. I'm sure I'm big enough to take them all, and I'll see Paul around the traps.
He may have said this partly in jest, but he calls you the shadow minister for boat people and whipping up racial tensions.
Well, look, I think that's pretty characteristic of the way the Labor Party deals with this issue. They want to sort of whisper one thing out in Western Sydney which says, look, if you have concerns about this issue, it's okay, we understand. But their true feelings, I think, are portrayed by Paul Howes. They've been portrayed by Stephen Loosley and Craig Emerson. They think this is all hysteria. They think it's just us whipping up issues. If that's their view, they should be honest about it. The Prime Minister, before the election, tried to say that wasn't her view. Well, I think their views are pretty plain. We don't think Australians who have these views are in any way racist. We think they're raising legitimate concerns, and for a long period of time we've always had a consistent position, as have the Greens. It's the government that is all at sea at this issue, and the High Court literally sunk them this week, and I wasn't surprised.
Scott Morrison, thanks for your time.
Thanks a lot, Barry.